Good morning, Ms. O'Reilly.
Good morning, Your Honors. Anne O'Reilly for the defendant, Ramey Tyree. At issue in this case is the warrantless entry and search of the defendant's residence and two subsequent searches that occurred over the course of the next few days. On the night of April 8th at 11 p.m., 6 officers entered the defendant's residence.
Your real concern is with the April 8th one, right?
I have a concern for all of the searches, April 8th, April 9th, and April 11th.
The April 8th one?
I'm sorry?
Could we focus on the April 8th?
Oh, of course we can focus on the April 8th one. Yes.
I guess my question that I wanted to ask is, the Commonwealth says, and I think you can see, probable cause that these two people are in the house, right?
I haven't conceded the probable cause issue for exigent circumstances, which the motion to suppress was based on. Which the judge found for the search.
You don't argue it.
Did you raise it in your application for further appellate review? The probable cause piece of your argument. I understood you had not.
I thought we were really focused on the exigent circumstances.
We were absolutely focused on the exigent
Let's
circumstances.
assume hypothetically probable cause. Okay. Officers are there, and you say, they had plenty of time to go get a search warrant. I think you might agree that in those circumstances, they would, as they did later, want to keep the house under surveillance, maybe even check it, right?
They might want to
keep it under surveillance?
They could keep it under surveillance, which they could have done. They had it basically under surveillance when they arrived.
But if they think that there is one or two people in there who are armed, is there some obligation on a safety issue to check that?
The situation as it appeared to the police on the night of April 8th, it was 2 hours. A convenience store had been robbed. They believed that the two, alleged robbers were inside the condo. The situation at the house was quiet. There was a van that was warm to the touch. It wasn't a situation where there was hot pursuit. The condo was quiet. There were no indications that anyone was inside the condo. I think some of the most important factors were that the exigent circumstances argument was not even raised at the motion to suppress hearing. The sole argument at the motion to suppress hearing was that the defendant's girlfriend consented.
Okay.
I
understand that, and the judge gave the parties time to answer, to brief the question. And it's not clear to me whether are you suggesting that because the Commonwealth didn't present with exigent circumstances at the hearing or in their initial post-hearing memorandum, that they should be barred from the judge, and they should be barred from getting into that issue at all?
Well, exigent circumstances requires probable cause and showing that the situation is so urgent that obtaining a warrant is impracticable.
Agreed, and maybe the evidence does or doesn't make it, but I thought what you just said was that because the Commonwealth didn't argue it the first time around, they should be barred from doing so. Is that what you're saying?
Whether or not they should be barred from doing so, I think the evidence at the motion to suppress hearing did not support exigent circumstances.
That's a different issue.
I think, if they were barred, if they're not barred, either way, that the argument does not support exigent circumstances. And as a matter of fact, even at, there was one police officer testifying at the motion to suppress hearing. Okay, and he also, the same police officer who claimed consent at the motion to suppress hearing, and that was the sole argument, also testified at trial. After, which was clearly after the motion judge found that there was not consent for the April 8th search, that same officer testified that Marquis had given him permission to enter the home. So he testified that there was consent at the trial as well. So, under the Fourth Amendment, there has to be a showing that there was some consideration that it was impracticable to obtain a warrant. And because the sole argument at the motion to suppress hearing was consent, there was no showing at all that they even considered obtaining a warrant.
What does the record say, if anything, about what this condo was? Is this a freestanding house? It's just a condo or part of a complex?
I believe it was part of a complex. It didn't. I don't think it went into detail about whether it was attached, but I think there was a common parking lot.
And the police were at reason to believe that there was someone else in that condo, the girlfriend, because they had been there before, or
they testified that they had been there before, and that they. Mm-hmm.
So what should the police officers have done? It's 11 p.m. at night. They have reason to believe that there were probably two armed men who've just committed a robbery, pointing a gun at somebody's head or stomach, I forget where. What are you saying the police should do? It's Tingsboro. It's a small town police force. What should they have done?
Well, under the Fourth Amendment, it requires for exigent circumstances that they consider obtaining a warrant, or that the situation is so bleak and urgent and unforeseen that obtaining a warrant would have been impracticable. And the fact that the behavior of the police officers belie their testimony that. Pardon me. They didn't even testify that there was exigent circumstances. It was really a fiction created by the motion judge after the motion hearing.
But let's try my question again. So, are you saying then that the police should have established surveillance there until they could have gotten a search warrant?
The house was quiet. The case law indicating that it's okay to enter a house under exigent circumstances without a warrant. There's some kind of evanescent nature to the evidence that they're afraid of being destroyed, or that someone inside a residence is in danger. Those factors didn't exist in this case. The condo was quiet. The van, it wasn't it wasn't the case of a hot pursuit. 2 hours had transpired between the holdup and the entry.
And but again, pragmatically, are the police? Are you saying that we should say that the police should have left and come back in the morning? Or are you saying that the police should have established physical surveillance all night until they could get a warrant and do a search? What are you saying the police should have done here?
A warrant, is potentially available 24 hours a day, and
that's what they should have done.
Well, if they were so worried about people inside the condo or the evidence, presumably they wouldn't have driven the clerk back to the convenience store before they entered.
Well, they didn't all drive him back, did they?
No, one officer drove him back, but they waited for that officer to come back before they entered. So that would indicate that they're not so worried about.
Well, they didn't have probable cause before then, did they? They needed the clerk of the store clerk to come and identify the van and provide some additional information before they had probable cause to arrest.
Well, whether the probable cause existed or not, they could have, they could have taken the clerk a block away if they were so worried about the exigent circumstances that existed. But I would argue again that there were.
Well, they had to bring him right up to the van, didn't they?
Excuse me?
Didn't they have to bring the clerk right up to the van?
They brought him to the van.
They had to bring him right up to the van.
Your point is they took the time to drive him back to the store before they actually entered the house.
Yes, they took him from the convenience store to identify the van, and then before they entered the house, their condo, they drove him back to the store, which was a distance of about 2 to 3 miles, and then they waited until that officer came back from that trip to enter the condo, which I would say that behavior does not indicate that they were so worried about evidence or people inside of the condo being harmed, which is required for exigent circumstances.
Now, the judge gave you the opportunity to file a memorandum of law on the question of exigent circumstances, didn't he?
After the motion hearing.
Okay.
Excuse me, even after the original motions were filed.
Did you ask for an opportunity to present any additional evidence at that point?
The defendant did not, no.
Okay. Did the judge indicate that he would not allow you to offer additional evidence if you sought to reopen the hearing?
There was an appeal from the motion to suppress, but there was nothing beyond.
But the judge never said at the time that he requested briefing on the issue of exigent circumstances. Did the judge ever say, I'm not going to allow anybody to produce additional evidence or offer additional evidence?
I don't believe the judge said that, no.
Okay.
He requested briefing on exigent circumstances and hot pursuit. And the Commonwealth, they briefed only exigent circumstances.
Was there any evidence about how long it would take to get a warrant?
There was none presented at the motion hearing, no. And I believe under Ford, this court has said that there has to be evidence that there has to be some indication, testimony that it was impracticable to obtain a warrant, and there was nothing. And again, I would reiterate that the same officer who testified at the motion to suppress hearing testified at trial that for the April 8th search that the defendant's girlfriend had consented to that search. Even at the trial, he didn't claim exigent circumstances, even after the judge found it.
Well, didn't one of the police officers mention in the course of his testimony that he entered, it may have been in passing, but didn't he say there was also exigent circumstances?
It was just one little, one little sentence. There was,
but he used the word exigency?
He did use the word exigent circumstances, but there was, other than that, there was no evidence at all of exigent circumstances.
If one says that the first search was improper for the reasons that you said, and you argue that tainted the search warrant for the second search on April 9th, April
Yes.
9th, right?
Mm-hmm.
The Commonwealth, I believe, argues that even if the first one were improper, if you excise the evidence, it would suggest that you wouldn't get evidence of the drugs and the shoes, I take it, maybe. But I guess my question is, what's your response to the Commonwealth's argument that even with that out, there was enough in the April 9th search warrant application to warrant a search warrant in any event on that day?
I argued and argue that all of the searches, the April 8th, April 9th, and April 11th searches are tainted, and because of the bad conduct of the police officers.
So you're just saying prophylactically one should say this can't be. Is that what you're saying?
I believe under the Fourth Amendment, Payton versus New York.
Ask you about the quote bad conduct. These police officers thought they had her consent. A judge, and I mean this with no disrespect, with 20/20 hindsight, said no, the consent wasn't voluntary. But certainly they knocked on the door. Somebody came to the door. The owner of the apartment came to the door, and I believe the testimony that was that the owner of the apartment said, "Go ahead, enter." Correct?
That's what the officer testified at the motion to suppress hearing. Yes.
And wasn't she a witness as well?
No, I'm sorry. The defendant's girlfriend, who was alleged to have given the consent, testified at the motion to suppress hearing that she did not consent to the entry of April 8th.
Okay.
So, sorry. I would argue that if there had existed exigent circumstances, the Commonwealth would have briefed it, prior to the judge requesting it to be briefed after he found that there was no consent. And I would argue that, the searches of April 8th, April 9th, and April 11th are tainted by the bad conduct of the officers. And under the Fourth Amendment, it requires that, considering, that obtaining a warrant is impracticable, and there was no showing at all that it was.
I don't have the judge's ruling in front of me at the moment, but my memory was that he He didn't say there had been no consent given. He said that what appeared to be consent had been clouded by her illness and waking up or something like that. So it wasn't voluntary, correct? I mean, I took that to mean that the judge found, and I'd have to look at it more carefully, that there was consent in the sense that she said go ahead, but that for circumstantial reasons that wasn't voluntary.
Well, I would say that vitiates the consent if it's not voluntary, and she testified that she did not consent, that 6 officers, she was sick with the flu.
No, I understand that, but again, it's just looking to your claim of, quote, bad conduct.
6 officers entered, her condo, guns drawn. She claimed that they took her from the apartment and asked her to step out onto the porch or the outside, and it was very, very cold. It was April, but it was a cold April. And that she was sick and that she was frightened that they would shoot her accidentally. So this is a woman who was terrified.
Thank you, Ms. O'Reilly.
Okay. Thank you, Your Honors.
Ms. Lugo?
Good morning, Your Honors. May it please the Court, Kimberly Rugo, Assistant District Attorney for Middlesex. This is a textbook case falling squarely within the narrow purview of the exigent circumstances.
If it's such a textbook case, why didn't the Commonwealth argue this?
Well, Your Honor, if you look at pages 114 to 117 at the motion to suppress hearing, that was the end of the hearing after the testimony. There was actually no legal argument by either side, which is common practice. The judge asked the parties to solicit memorandum of law subsequent to the hearing. In addition to that,
But you didn't argue it in the memorandum of law either, did you?
No, Your Honor, and neither did the defendant. Certainly,
But it's your issue.
Yeah, it's your burden.
there's no question that it's the Commonwealth's burden to justify the warrantless entry in this case, and that the officers believed they had the consent, and we thought that we proved the voluntary consent.
I understand. So, I mean, this was all done on the basis of consent.
In terms of, we submitted an initial memo on the issue of consent, correct? And then we supplemented that with exigent circumstances. Certainly, you only have to justify the warrantless entry on one ground. So if we would win on consent, then there's no need to argue exigent circumstances.
No, but you began by saying it was a textbook case for exigent circumstances, and I think we're sort of reacting, well, if it was a textbook case, you didn't start there, so.
That's right. I mean, I think it appeared as well that it was a textbook case of consent.
So how do you know you won on consent? How did you know you were going to win on consent?
Well, we didn't.
So why didn't you argue exigent circumstances as well?
Again, there wasn't an opportunity to even argue.
Excuse me?
There wasn't an opportunity.
Excuse me? No, the judge cut you off and said you can't argue exigent circumstances?
No, Your Honor.
Well, then there was an opportunity.
Regardless of whether
There was an opportunity.
the legal argument, I guess, was presented to the judge via the memorandum of law.
And go around.
Excuse me?
Second go around.
That's right. Regardless of that, there were ample facts at the motion
The
hearing.
difficulty is when you've got a record where there's apparently been no evidence. I mean, it's helpful to know, for example, how long it would have taken to search. I mean, generally speaking, you look to see whether or not evidence is going to be destroyed. The classic is drugs flushed down the toilet. Here you had clothing, you had weapons, all of which could have been contained if there had been surveillance. I'm not getting into Justice Ganser saying what the police should have done, but what could have been done. There was nothing to suggest that these people were going to flee.
Exigent circumstances is not simply defined by the loss or destruction of evidence. And, in fact,
Of course, I know
that could justify exigent circumstances in and of itself. And I think the exigent circumstances exceptions to the warrant requirement, there are a few different exceptions to the warrant requirement, and over time the different theories are conflated in the case law. But exigent circumstances under Ford, Commonwealth versus Ford, which is the case upon which the motion judge relied, this case falls squarely within those factors. Number one, you have a violent offense that was recently committed. There was evidence at the hearing that the assailant, the defendant, attacked the victim, put him in a chokehold outside of the store, pointed a gun to his stomach, demanded money.
I don't think there's any question that there was a violent crime committed here.
And there's no question either that one of the other factors that both suspects were armed with a firearm. There was evidence at the suppression hearing that the victim told Chronopoulos at the scene that he observed both men with firearms. Also,
The defendant says, I think with some accuracy, that there may be some obligation on the Commonwealth's part in arguing exigent circumstances to put in some evidence as to why obtaining a warrant would be impracticable.
well, there's no requirement that that the Commonwealth must have direct evidence of why or how long it would have taken to obtain a warrant. To get any warrant, a search warrant or an arrest warrant, takes some time. And it's the nature of the exigency, meeting the exigent circumstance factors under Ford, that makes it impracticable to get the warrant.
Ford, they found the court concluded there were no exigent circumstances, correct?
That's correct in that case. That case is easily distinguishable from this case in that case there was a 6-month drug investigation going on. The house had been under surveillance for a week. Here
I'm reading from Ford, on which you rely so heavily. Under the exception for exigent circumstances, there must, the court's word, be a showing that it was impracticable for the police to obtain a warrant.
That's correct.
Was there any showing in this case that it was impracticable for the police to obtain a warrant?
Yes, Your Honor.
What's the showing?
The showing was that the crime had just been committed.
That means that any time the police suspect somebody and it has just been committed and they have probable cause to believe that the suspects are there, you've got exigent circumstances. Well,
no, Your Honor. I mean, I think also the court is looking at what the police are doing at the time. A common denominator in these cases is looking at what the police are doing at the time they learn of the crime, develop the probable cause, establish that the...
I'm simply focusing on the showing that it was impracticable for the police. I mean, the Commonwealth presumably could have asked, I'll ask Justice Spina's question to you, the Commonwealth, when the judge said no to consent, the Commonwealth said, well, then we'd like to reopen the hearing and show that it was impractical to get a warrant.
It was established at the motion hearing because it was imperative that the police act to secure the robbers and their firearms.
Why was it imperative that they act to secure the robbers and their firearms? Could they not have kept the house under surveillance?
Well, certainly they could have, but that would have risked any number of things. First of all, it wouldn't have been helpful if neither of the suspects were inside.
I'm simply trying to understand, and perhaps I'm not asking the questions very clearly, Ms. Lugo, what would make this situation different from any other situation where in the close aftermath of a crime, the police have probable cause to believe, violent crime, with the probable cause to believe that the perpetrators are in a location. I don't think we've ever said that in those circumstances no warrant is required.
Well, certainly there's a strong reason to believe that if they don't act to apprehend the suspects immediately, there is a risk of flight.
But there's no evidence of a risk of flight. This was at 11 o'clock at night.
Well, certainly...
The police were not in hot pursuit. To their knowledge, the alleged perpetrators didn't even know the police were there.
Well, the police didn't know whether or not they knew they were there. That's correct.
I understand.
But the police were outside the condo.
You can say those things, but then you have to concede that in every case where the police have probable cause to believe that the perpetrators are in a location in the wake of a violent crime, that no warrant is required.
Well, no warrant is required if you do meet those Ford factors. And it's not...
You have to have evidence.
That's correct, Your Honor. And the evidence, in addition to the evidence, the court is concerned about, as I was trying to say earlier, there is a common denominator in the precedents where if the police are acting quickly and there's no delay, there's no unreasonable delay by the police, from the point at which they learn of the probable cause and locate the suspects, a warrantless entry will be held to be reasonable and lawful. It's looking at the totality of the circumstances at the point of the entry and looking at it from the viewpoint of it's an objective standard, looking at was the police conduct reasonable at that moment. It's certainly reasonable for the Tingsboro Police to believe that they need to secure 2 armed robbers and a firearm in a row of condominiums. I believe Justice Cordy asked earlier if there was evidence as to the setup of the condo. It was a townhouse-style condominium. If you look at the motion to suppress hearing at pages 48 and 94,
Well,
there were
if this were an assault and battery with a dangerous weapon and not a robbery of money, where money had been taken, if this was simply an assault and battery by means of a dangerous weapon and a gun were used, could the police appear at somebody's apartment 2 hours after the barroom brawl and just crash through the door and take charge of the situation?
Again, it's a spectrum of reasonableness. I mean, I think it depends
What's the
on
answer to
how.
that? What's the answer to that question?
Well, whether they could crash down the door, certainly peaceful entry is one of the factors to look at. In this case, the judge found that the entry was peaceable.
Well, so leave aside the crash down the door. Could they have, gone into an apartment? Somebody knock on the door, open the apartment, they push their way in.
And I'm sorry, the crime was.
Assault and battery assault by means of a dangerous weapon.
Serious crime.
I mean, there is the potential if he's armed with a firearm, say, for example.
So anytime someone has used a firearm in the commission of a crime and assaulted somebody, the police can essentially go into their apartment.
Again, it's looking at the totality of the circumstances as it appeared to the police at the time. I mean, these are very fact-specific situations. Whether it could be any time, I don't know if I could say any time. Yes, they would be.
Take these facts. If the police had got a battering ram and knocked down the door, would that have been permissible here?
I think it would have been, actually. And this court decided Commonwealth versus Moran back in 1977 on facts very similar to this. An armed robbery. They developed the probable cause. They located where the suspects were, and that there was a forcible entry in that case. And
is it because there is money involved that could be destroyed, or is it because they have guns?
Again, that's another factor that
Here,
this court can look at.
in this case.
Well, it's certainly both, and the judge found both. The judge, there's no question that they're armed with firearms.
Why
the judge.
Couldn't have been money. Just money. Could it have been?
Why are they going to destroy money? They don't know the police are there.
It's not destroy. I'm sorry. It's not destroying money, but certainly the need to ascertain the money, to get the money and use it as evidence later, or to recover it for the victim. Money is easily changing
if they've
hands.
got the house under surveillance and the people are leaving, that's one thing.
But the police don't know for certain whether or not the suspects are inside until they go in. I mean, the suspect, and actually Hoffman was not found inside. So until they actually make the entry, there's no.
Or until they wait and see if somebody leaves the building.
But in doing so, any number of things could have happened. They knew that both
What
Hoffman.
could have happened?
Well, they knew that potentially that Hoffman and Tyree potentially were there with another person inside. They didn't know if
But
they
what
would
could have
become.
happened?
They would be noticed. Certainly, there had already been activity in the parking lot outside of the home. There was police activity whereby they were bringing the victim to identify the van, and then back to the store. Police were gathering outside. There's no way to know for certain whether or not they had been noticed. And once they are noticed, certainly there is always the risk of flight and thereby destruction of evidence. In addition, there were other condos. It was 11 o'clock at night. You can reasonably infer that people are expected to be inside.
They couldn't have fled, right? They would have been apprehended. Probable cause to apprehend them. They tried to flee. So when you say there was a risk of flight and thereby the destruction of evidence, not quite sure that I understand that.
I'm sorry. I guess I'm not understanding you.
You said there was a risk of flight and thereby the destruction of evidence. I'm not quite sure that I understand.
Maybe I'm not sure. Maybe I misspoke. But certainly, if the police were outside, that could potentially, and they get noticed, that could lead to, potentially they could run out the back door. There was evidence that there was, a back door to the condo.
The back door was there evidence that the back door could not be placed under surveillance?
No, but again, and there were officers there, and officers did go to the back door eventually, but at any point, the officers could have been noticed in the parking lot, and anyone could have fled out the back door prior to them securing the back. And once they're even once they're at the back, assume they have officers posted at the back and at the front. At that point, they still don't know who for certain is inside. And certainly, it is a risk to public safety to have two masked armed robbers on the run, armed with firearms.
But haven't we come full circle? Isn't that the problem of it not being raised in the hearing? Because there's no evidence that the police testified to that their numbers were inadequate to secure the space or to do a proper surveillance or to guard against the possibility of them leaving. I mean, that's not part of the record, is it?
There's no requirement that, but certainly this court could infer that they had to wait for Sergeant Konopoulos to enter the house. They had the chief of police actually on the scene, and they had to go there with. There's a finite number of resources. I think this court can reasonably infer there's a finite number of resources, and that 6 officers were required to make this entry here.
But it would seem that we would also need evidence that there were not enough resources to do a proper surveillance and therefore not enough resources to allow them to wait until they could get a warrant. But I don't know that we have that.
Any
evidence,
number.
right?
I mean, any number in Commonwealth versus DeSanto, which I believe the motion judge relied on. In that case, there were 100 Boston police officers looking for armed robbers on the run, and even in that case, where they found that there was no risk of flight in that case because of the number of officers, they had a helicopter, etc. The warrantless entry in that case was still found to be lawful and proper because the other Ford factors were met.
In Ford, as I understand it, even though there was evidence that the people that were about to be apprehended might be warned, the court still said not enough, correct? I mean, that was supposedly the exigent circumstances.
I'm sorry, can you say that again in Ford?
In Ford, the question of if people know that they are being surveyed, under surveillance, it might lead to the concerns that police have, destruction of evidence and so on. There was evidence that there might be a warning because somebody was about to be released.
That's right, and that went right to the destruction of evidence, and the court said that wasn't enough because the other Ford factors were not met. In that the crime was not recently committed, it was not it was not a violent crime, and so that is an important factor to take into consideration.
Thank you, Ms. Lugo.